I'm Mathew Healey and I'm one of Bates Wells Braithwaite's in-house chartered trademark attorneys. Trademarks, names, logos, slogans are your organisation's identity. And when you allow someone else to use your branding, effectively to borrow that identity, you blatantly need to think carefully about the terms on which you let that happen. By this video, I wanted to tell you about 5 key things you need to think about when licensing others to use your name or brand. First, define the scope of the license. This sounds obvious, but it's one of the main areas in which things go wrong. You need to be very clear as to what it is the other guy is allowed to do. So, for example, for what activities can they use your brand? Is it a single event or a campaign, or does it go beyond that? Second, how long does the permission last for? So you don't want, for example, a situation where the other guy can use your brand ad infinitum. And you need to think about the geographical scope too. Are you happy for the name just to be used in London, across the UK, or is there no limitation? The license document that you agree on needs to be explicit on all these things. Second, is the license sole or exclusive? In a similar vein, you need to be wary of the words sole and exclusive. When these appear in a license, sole means that you can't grant a license of the same rights to anyone else, but it's exclusive that you need to be really careful of. That means that no one else can use the brand in question for the specified activities, including the person granting the license. Sometimes you'll want this to be the case, but more often you won't. Next, money. What are you getting in return for use of your brand? Is it one-off payment, a monthly royalty, or something else? In fact, it's not unusual for a charity to want to give someone the right to use its name for free, a local partner, for example. But bear in mind that a trademark license is a vatable supply, and the taxman may want a payment corresponding to the market value of the license. But that's a really complicated area on which you should always seek professional advice. Also, you need to think about warranties and indemnities. Be careful of these. These are legal promises that the trademark owner gives to the person licensed to use the brand. The person licensing the brand will sometimes warrant that using the name or the logo won't step on anyone else's toes and will indemnify the other party in that respect. In other words, it will promise to cover the other guy's losses if that happens. If you're licensing an established brand in an established area of activity, then it's probably safe to do this. But if the branding in question is new or is being used in a new way, you need to be more careful. One approach is to check with your solicitor or trademark attorney whether the brand is free to use in the way you propose. They can carry out searches that will hopefully give you peace of mind. Last, termination. You need to think about the circumstances in which you can bring the arrangement to an end. Certainly you'll want the option of doing this if the other party is not keeping its side of the bargain, if it's not paying any license fees that are due, for example. You may also want the license to finish simply because the arrangement no longer works for you. It could be wise to include a provision that allows you to terminate simply by giving, say, 3 or 6 months notice. Also, and we think crucially, you should consider adding a clause that allows you to immediately terminate in the event that the other party does or threatens to do anything that will potentially bring your charity into disrepute. As we've already said, your brand is your identity, it's a key asset, and the worst case scenario is that your licensee does something to cause your recognition and reputation irreparable harm. The best way of avoiding this is, of course, to pick who you work with carefully. But as a fail-safe, we think it's essential that you have a way of addressing concerns of this kind at the first sniff of trouble. And one last thing, be aware that when you're entering into an agreement with a commercial participator, so that's the sort of arrangement where 10p from every packet of crisps sold goes to charity X, or with a professional fundraising company, there are specific rules that need to be followed. These include the need for compulsory clauses about how much the donation or the cost of the sale goes to charity. There's not time to cover this in detail here, except to say that you need to abide by these rules. If they are broken, the agreement may be unenforceable and you may lose out on funds that are due to you. you have any questions about the content of this video or anything to do with licensing or even trademarks generally, don't hesitate to drop us a line. We love talking about trademarks, and we're always happy to have an initial consultation free of charge.